Okay, we are live on YouTube. Hello and welcome everyone to the 2022 John Black Moot Court Competition Finals presented by Norton Rolls Rose. Okay, we are live on YouTube. Hello and welcome everyone to the 20. Sorry about that. Had some feedback. Presented by Norton Rose Fulbright. I'm Michael Moore, the competition director this year. This competition has lasted over the course of the weekend. We've had 16 incredible teams, all 1L teams that have culminated to this moment with our top two teams competing to be this year's champion. We have a number of incredible judges, and I can't wait to get things started. So without further ado, we will jump right in.
Good evening. Before the court of the Lone Star Court of Criminal Appeals this evening, we have the case of Count Olaf versus the state of Lone Star. Both sides have been granted 25 minutes to speak before the court on the presented issues. When counsel is ready to proceed, we may begin.
Ready, Your Honor. Thank you. And may it please the court. My name is Nathan Hellaney, and along with Beth Gillespie, I represent Count Olaf, the petitioner in this case. I would like, with the court's permission, to request 2 minutes for rebuttal.
Granted.
Thank you, Your Honor. I would also request that we divide our time between myself and co-counsel, 12 and a half minutes for myself and 10 and a half minutes for my co-counsel, Ms. Gillespie.
So granted.
Thank you, Your Honor. Would the court care for a brief recitation of the main facts?
No, thank you. Please proceed with your argument in chief. Unless my co-justices would like a recitation.
We've read the briefs. We don't need a recitation of the facts.
Thank you for offering, counsel.
Thank you, Your Honors. This case highlights important constitutional principles: the First Amendment right to free speech, the Sixth Amendment right to a fair trial, and the 14th Amendment right to due process. These fundamental constitutional rights were violated in the prosecution and trial of Count Olaf in two main ways. First, the overbroad statute under which Count Olaf was convicted violates the First Amendment protection for free speech. Therefore, we ask the court to find the statute unconstitutional and vacate the conviction. Second, the outburst by the spectator and the trial judge's improper response violated Count Olaf's right to a fair trial and to due process. Therefore, if the statute is upheld, we ask the court to reverse the conviction and remand for a new fair trial. I will show why Lone Star Penal Code section 78.021 is an unconstitutional restriction on protected speech, and Ms. Gillespie will show why the spectator's outburst and the trial judge's improper response violated Count Olaf's right to a fair trial and to due process. Section 78.021 is unconstitutionally overbroad for two reasons. First, it prohibits speech that is protected under the First Amendment of the Constitution. And second, it is not narrowly tailored to serve a compelling state interest. The statute does not just prohibit unprotected categories of speech, such as child pornography and obscenity. It also sweeps too broad and prohibits a substantial amount of protected speech. For example, the statute prohibits the conveyance of any visual depiction that is or appears to be of a minor engaging in sexually explicit conduct. This includes not just child pornography, but also protected forms of speech, such as films with adult actors who look like minors.
But isn't the question not so much the prohibition of that type of image itself, but the reason for which it's conveyed? Isn't that more the issue at stake here?
Well, in some ways, yes, Your Honor. If the state were prohibiting the use of these materials to solicit minors for sexual acts, that would be much closer to being permissible constitutionally. However, this statute is not narrowly tailored to only prohibit the use for such acts. As that statute is written, it prohibits the use of such images to persuade minors to engage in any illegal action, not just the kind of sexual acts that the state has a compelling interest and designed this statute to protect against. Does that answer your question, Your Honor?
Well, give me an example of, besides obviously a sexual purpose, which I think that everybody would agree that sex with a minor for somebody who's outside the limit of of that age range would obviously be illegal. And so tell me other types of illegal activities that you feel like the conveyance of such speech would be okay for.
Well, Your Honor, so there's a number of potential activities that could be prohibited that wouldn't even come close to that kind of act. For example, imagine one high school student, because another problem with this statute is that it is not limited to conveyance by adults, it's conveyance by any person. So imagine one high school student offering to another high school student to watch a film that is neither pornography under child pornography under Ferber nor obscenity under Miller, but does contain scenes that appear to depict minors engaged in sexual acts, and uses that offer to convince their friend to skip school in violation of truancy laws, or to leave home after curfew has started. Technically, that person would be convictable under this statute. Now, this kind of behavior, while maybe illegal, is extremely minor, but the penalties imposed by this statute are severe. Count Olaf was convicted to 20 years in prison. So for a statute with such severe criminal penalties to sweep overbroad and include such minor violations is simply inappropriate. And it also does not further the state's compelling interest in protecting minors from sexual predators, which is the purpose of this act.
And yet we have prohibited, and we do allow the regulation of otherwise free speech. For example, the George Carlin broadcast that is seen to be not obscene, but, you know, offensive. Wouldn't this be closer to that type of speech?
For several reasons, Your Honor, I would respectfully disagree. I think that case is distinguishable in a couple ways. Now, first, that case had to do with radio broadcasts. And as the court noted in that case, radio broadcasts have the least protection of any kind of media for speech under the First Amendment. Second, that case dealt with an adjudication by a regulatory body of a specific factual instance, whereas in this case, we're dealing with a statute that could have broad and unforeseeable applicability. And so in the decision that the court came to in that case, I think was contextually bound. And there's one more difference, which is in that case, the speech was not banned and it was not criminally penalized. Instead, it was channeled using nuisance principles. And the only penalty that was imposed was a sanction that was not a criminal sanction. And so for those three reasons, Your Honor, I would say that case is distinguishable from the case at hand. Does that answer your question, Your Honor?
Please continue.
Thank you, Your Honor. So not only does this statute sweep further than child pornography, and as the court noted in Ashcroft v. Free Speech Coalition, which was concerned with a statute that is very similar to the statute in this case, this statute would technically ban things as wide-ranging as Renaissance paintings that sometimes depict minors engaged in sexual acts, images contained in psychological manuals, films depicting the horrors of sexual abuse. It's not limited to child pornography. Similarly, it's not limited to obscenity under the Miller test. Under that test, the government must prove that the work taken as a whole appeals to the prurient interest, is patently offensive in light of community standards, and lacks serious literary, artistic, political, or scientific value. While the court in Ginsburg did find that the definition of obscenity can vary depending on the group the speech is directed to, such that what is not obscene for adults may be obscene for minors, Section 78021 is not confined to material that is obscene for minors. Here, the statute's ban on any—
But you would agree, just as a just baseline issue, you would agree that the state of Lone Star has a compelling interest in prohibiting the online solicitation of sexual activity by minors, would you not?
Absolutely, Your Honor. We would not dispute that.
All right. And so if your idea is that this is a narrowly tailored issue, essentially, let's go to number two. Let's go to your second argument really quickly.
Yes,
How would you suggest that Lone Star make a change to its statute if it did want to criminalize such online solicitation?
Absolutely, Your Honor. There are several ways that we believe the state of Lone Star could change this statute to make it more narrowly tailored. First, as I said before, this statute does not only apply to adults, it applies to any person, and that includes minors. And so if the statute is intended to prevent the predation of minors by sexual predators, it could be limited to behavior by adults. Second, it bans the persuasion of minors to engage in any criminal behavior, no matter how minor. That's far too broad, and the statute could easily be rewritten to only prohibit persuading minors to engage in sexual acts or other acts that the state has identified as it's having a compelling interest to prevent. And third, the statute—
Counsel, if you were to limit the statute to only apply to adults, wouldn't that result in the same outcome in this case? Because Mr. Olaf was an adult?
It would in this case, Your Honor. That's absolutely true. And that is not the only feature of the statute we believe is overbroad. Even if that were changed on its own, we still believe the statute would be overbroad, unconstitutionally overbroad. However, it could apply to other cases. And because the court is considering the statute as a whole, we believe it's an important factor.
And Counselor, so you're painting this picture of potentially constitutional speech, speech that's fits under the First Amendment as protected speech that would be outlawed by this. But doesn't the inclusion of the illegal activity aspect of the statute still only criminalize already criminal behavior? I mean, what's really the constitutional issue? What constitutional speech is being chilled that wouldn't already have criminal penalties?
The problem here, Your Honor, is that it criminalizes offers. And now, if this statute were narrowly tailored to only prohibit the kinds of illegal acts that the state had a compelling interest in preventing, then prohibiting the offer would not be as problematic. The problem here is that it's an offer to engage in any criminal activity, including the example I gave earlier of something as minor as skipping school, violation of truancy laws. Another issue here is
Counselor, if I may just dissect your argument, because it seems to actually bring up a little more than I anticipated potentially. Is it your argument that regardless of whether we say adult or child or what have you, that the speech itself, that whatever it is, that no matter what, the Lone Star statute would be overbroad because the types of speech are overbroad? So can you speak to that? Because it seems that you said that there are types of, that this is essentially a CPAA kind of issue.
Yes, Your Honor. If this speech were limited to sorts of speech that are not protected by the First Amendment, obscenity, child pornography, then there would not be an issue here. The problem is that it sweeps so broadly that it includes all sorts of speech that is not obscene under Miller. It includes speech that does have redeeming value, that is not offensive in light of community standards, and that does not appeal to the prurient interest. As I said, this could include a film depicting the horrors of sexual abuse. Nobody could say that that appeals to the prurient interest, but it would be banned under this statute. And because that is the case, strict scrutiny applies as put forth.
So basically, even let's say that it was very specific. You can't send these images for purposes of eliciting child sexual activity. Still overbroad then?
No, Your Honor. In that case, it would be allowable because the state has a compelling interest in protecting minors from sexual predation. If the statute were narrowly tailored and it only banned the use of this speech to engage in that illegal activity that it has an interest in preventing, then it would be much closer to surviving strict scrutiny. And I see that I only have 30 seconds remaining in my time, Your Honors. Could I take a brief moment to conclude my argument?
Yes, please.
Thank you, Your Honor. So we argue that because this statute is not narrowly tailored and it prohibits protected classes of speech, strict scrutiny from Ashcroft v. ACLU does apply. In that, under strict scrutiny, Content-based prohibitions on speech are presumed to be invalid, and the government bears the burden of showing that they are valid. To do so, the government needs to demonstrate a compelling interest, and also that they have used the least restrictive of available effective alternatives to achieve that interest that are necessary. While they may have demonstrated the first, they have not demonstrated the second, and cannot, as the statute is written. And I just want to briefly mention that in addition to rewriting the statute, they could also use other techniques such as filters.
Okay, now we're arguing, Counselor.
So sorry, Your Honor. Thank you very much.
Thank you. We may proceed with speaker 2, Ms. Gillespie.
Thank you, Your Honor, and may it please the court. My name is Beth Gillespie, and along with Nathan Hellaney, I represent the petitioner in this case, Count Olaf. I will show that even if the statute in question is constitutional, this court should reverse Count Olaf's conviction and remand for a new trial. The trial judge erred in refusing to grant a mistrial or to provide at least a limiting instruction in response to a spectator's accusatory outburst in the presence of the jury. First, this outburst violated Olaf's Sixth Amendment right to a fair trial by an impartial jury and 14th Amendment right to due process. Second, the trial judge should have granted a mistrial or at a minimum provided the jury with a limiting instruction to disregard the outburst and base their verdict only on the evidence introduced during the trial. Finally,
trial, the judge actually tried to say something that, well, that was not, let's just say partial. It didn't say whether it believed that Count Olaf had molested a child previously. It said that the trial court specifically said, this has nothing to do with the case at hand, we move on. So how can that be prejudicial?
Your Honor, respectfully, we believe that the comments by the judge actually compounded the error because if I could draw your attention to page 5 of the record to look at the exact words that the judge said. The judge told the spectator to sit quietly. She could sit quietly or leave unless she had more information about how guilty he is of his latest sexual misconduct. We believe that jurors reasonably could have understood those comments to be indicative of his guilt. And because those comments were unchallenged and there was no opportunity to question the witness, to challenge the witness, and then those additional comments from the judge could have just compounded the error and that prejudicial environment that Olaf
So
did.
do you have any evidence that the comments actually did prejudice the defendant in this case?
If you look to page 6 of the record, there was some indication that they did hear about these things. Well, I mean, obviously they heard about them.
Obviously, we know they heard about them, but
Yes,
is there any evidence that the defendant was actually prejudiced by the comments made? And does that make a difference from a legal standpoint?
We do not have any direct evidence that they were directly prejudiced. But when we look at some of the similar cases, we can see that it may have created, it likely did create actual or inherent prejudice. You can look to Holbrook v. Flynn for some guidance on how to assess prejudice. If a courtroom arrangement is challenged as inherently prejudicial, the question is not whether the jurors articulated awareness of a prejudicial effect, but whether there was an unacceptable risk of prejudice. And a court should consider whether what the jurors saw was so inherently prejudicial as to pose an unacceptable threat to the defendant's right to a fair trial. And we believe that's what happened here, that was just inherently prejudicial and threatened the defendant's right to a fair trial.
So was it because the judge, was it because the judge said, if you have more evidence, essentially you should stay, and the fact that she stayed? In other words, as she turned around and left, would that have alleviated your concerns?
Your Honor, I'm concerned with her language of how guilty he is, to me implies guilt. Of his latest sexual misconduct implies that there was previous sexual misconduct. So those are the problems with the words that I think made this an inherently prejudicial situation. And then the spectator did stay in the court for the rest of the time. And I think that matters as well. And the fact that the allegation from the spectator was similar to the crime that Count Olaf was on trial for also made a difference. And there are a couple of Delaware.
Even if the count was related in terms of, these are both potentially sexually related crimes, they're still two different crimes, and juries are smart enough to understand that guilt in one instance doesn't necessarily affect guilt in the present instance. I don't understand how those two separate crimes would be prejudicial in this case.
Your Honor, respectfully, I worry that we may be giving jurors a little too much credit there. I think they rely on the instruction from the court, and they did not get an instruction here. They did not get a limiting instruction directly to disregard that. The comments from the judge were directed only at the spectator, not at the jury, despite the defendant's request for a limiting instruction. The judge refused to instruct the jurors to disregard that directly. And I think that's the responsibility.
So, Counselor, you agree that if there had been a limiting instruction, that this issue would be moot, correct?
I'm sorry, Judge, could you repeat the question?
Yes, and so you can see that if there had been a limiting instruction, that this issue would have gone away, correct?
If, Your Honor, if the judge had issued a limiting instruction, I think this would have been a much closer call. I think because there was no limiting instruction, it is definitely error. There was definitely a prejudicial environment. We might have been arguing whether there should have been a mistrial anyway. And there are a couple of Delaware cases that I think relate to that as well, where there was a limiting instruction. Despite that limiting instruction on appeal, the appeals court, well, actually it was the Delaware Supreme Court, decided that there should have been a mistrial in both of those cases. But if there was a limiting instruction, maybe it would have been okay, but without it, it definitely was not okay. It's our contention. Does that address your question? Okay. So I'll mention those Delaware cases I was just bringing up. One was Ashley v. State, and that was the one with there was a prison stabbing, and then there was a spectator outburst accusing the defendant of having previously stabbed him. And the other Delaware case was Gomez v. State. And in that one, the court recognized that a limiting instruction can often be a meaningful and practical alternative, as you were bringing up, Judge Ju. But it was not there, because that testimony about the prior bad act created an impermissible inference that the defendant had committed the crime he was on trial for. And so
what I worry about, though, is that if we start saying that any outburst per se might be grounds for a mistrial, even if a limiting instruction is granted, then you could, and this is tricky, have a criminal defendant who can see that things are not going well for them at trial, have somebody just make an outburst like this and invalidate criminal trial after criminal trial. Isn't that a policy issue we do have to worry about?
Respectfully, Judge, I think maybe theoretically, but
I mean, you say theoretically, that could grind the wheels of justice to a halt. If any outburst would result in a mistrial, if, as she said, a defendant would just hire someone to come in and accuse the defendant of a similar crime. It's a get out of jail free card. So where do we draw the line to prevent that?
We could start with a limiting instruction, Justice. Judge, we didn't have a limiting instruction here. So I think that does make this a clear case of a violation of that Sixth Amendment and 14th Amendment right of due process. it was an inherently prejudicial atmosphere because of that, and that's a constitutional violation. And I think that the judge just had a responsibility to protect that presumption of innocence to which all defendants are entitled.
Since this seems to be a case of first impression, we have nothing in the record. What would you say, what would you argue should be the standard of review with respect to appellate procedure? Is it going to be de novo every time, where we have appellate court after appellate court looking at every outburst, at every statement, at every limiting instruction? Will we give trial court some deference? What's your standard?
Your Honor, certainly we're looking at this de novo at this point.
For the future. For the future. Perhaps a minimum of a limiting instruction, and then some questioning of jurors to determine the level of influence that the outburst had, to determine if a more drastic step is necessary. So I see that my time is short. May I briefly conclude? Yes.
In conclusion, Your Honors, we respectfully ask the court to vacate Count Olaf's conviction on the grounds that the statute violates the First Amendment. Alternatively, because the trial judge refused to grant a mistrial or limiting instruction, thereby denying Count Olaf a fair trial, we respectfully ask the court to reverse and remand for a new trial. Thank you, Your Honors.
Thank you. And now we have respondents for the state of Lone Star.
Thank you, Chief Justice, and may it please the court. My name is Jose Vega, and along with my co-counsel, Justin Binyard, we represent the respondent, the state of Lone Star. We respectfully ask for a time of 12 minutes for myself, and for my co-counsel, Mr. Binyard, 13 minutes for us to address our respective issues.
Granted.
Thank you, Your Honor. This is a case about the state's ability to constitutionally use statutes and procedures to protect children, and a reversal today would undermine the state of Lone Star's commitment to this cause. Now, we are here today because the petitioner has appealed the lower court's decision under a de novo standard of review over two particular issues. In my time before the court, I will address the first issue, which would be the constitutionality of the Lone Star Penal Code 78.021 and its effect on First Amendment rights, while my co-counsel, Mr. Binyard, will address the implications of an outburst amidst a trial proceeding as it affects 6th and 14th Amendment rights. Now, there are two reasons why this court should affirm the judgment of the 15th Court of Appeals on the first issue. Firstly, the language of the statute itself is narrowly tailored in response to harms which the state has a compelling interest in preventing. And secondly, the statute refrains from imposing undue burdens on constitutionally protected speech through its very language and adherence to case law standards. Now, first, on my first point, the language of the statute is narrowly tailored to prevent the harms which the state has a compelling interest in preventing. And on page 6
Counsel, you're aware that we have stated that there are things that are overbroad when it comes to depiction of child sexual activity. For example, Renaissance paintings, those kinds of things. I don't know if you've seen the HBO show Euphoria. That show also depicts adults portraying students, minors, engaging in sexual activities. So according to your argument, the sending a clip of that show from one person to another would per se be illegal, would it not? We run into the CPPA issue we had in the Ashcroft case.
Your Honor, I would respectfully disagree. The petitioner may argue that the Lone Star Penal Code section 78.021 bears similar language to the Child Pornography Protection Act of 1996, which was at issue in Ashcroft v. Free Speech Coalition. And that particular statute was deemed unconstitutional because of the fact that it was determined to be overbroad in its application. And though it might have very similar language to the Lone Star Penal Code 78, as is present here, as far as it states any visual depiction is or appears to be, that particular statute and this particular statute may be differentiated by one very meaningful aspect, the inclusion of a mens rea element in accordance with Davis versus State. And in Davis versus State, it was stated that due to the importance of the freedom of speech, there must be an implication or an accordance of a mens rea element to provide greater clarity.
So where's the mens rea that you're referring to? Is it the use of the word knowingly at the beginning of the statute?
Your Honor, this may be located on page 6 of the record itself. It is stated that the Lone Star Penal Code, Section 78, states that a person commits an offense when they knowingly distribute, offer, send, or provide a minor with any visual depiction.
Stop. The question was that the mens rea at issue? Or
Yes,
is the mens rea dealing with the second half of the statute, the in order to?
Your Honor, the mens rea here is knowingly distributing, offering, sending this, knowingly. That is.
And that's what
Accidentally.
differentiates. I'm sorry. And you're saying that's what differentiates 78.021 from the statute that was involved in the, I think it was the Ashcroft case?
Well, Your Honor, I would say that it differentiates it both unknowingly and the fact that there is an inclusion of for the purposes of inducing or persuading a minor to participate in illegal activities. So I would say that it differentiates on both aspects because this language was not present in the Child Pornography Protection Act of 1996.
Okay, so here's the problem though, is there's been the argument that individually, so if you have part A, which is the type of speech, with part B, that they're both in a way so overbroad that it violates free speech. I can see potentially arguments where you have speech which otherwise would be fine, but if the purpose were to elicit indecency with a child, sexual assault of a child, something to that effect, that might not be okay. I can see that argument. Or I can see the argument that you would have the narrow speech, no child pornography at all for any reason. I can understand both, but when we have the confluence of both, there seems to be a problem. Can you address that?
Your Honor, may you clarify the question?
Absolutely. Now, you have two parts of this criminal statute, and I can understand if you were to say, hey, let's say that you have part A is fine if we were to narrowly tailor the activity, because any illegal activity at all, opposing counsel has said that's actually too overbroad. Mm-hmm. That if you're eliciting truancy, this can't be a felony statute. If you're trying to elicit open container, it can't be a felony statute. It would be too harsh, too overbroad. On the other hand, I can understand that if you have absolutely fine, okay, here's a picture of a cell phone. I'm going to send you this picture of a blank cell phone with dogs, but you think dogs are cute, and so you, a minor, should engage in a sexual illegal act with a adult. That also could be illicit, arguably. But what co-counsel is potentially stating is the having both together, that's the problem. So can you tell me why having both together, because you're telling me individually A is okay and individually B is okay. I want you to explain how A and B is okay.
Yes, Your Honor. Thank you for the clarification.
No problem.
So as stated in Ashcroft v. Free Speech Coalition, this was an issue where it essentially was sober broad, and essentially a parent could not only put on a movie such as Romeo versus Juliet or anything that had this depiction of could be deemed as sexually explicit behavior, is or appears to be. And they could find themselves going through jail, being convicted under the CPPA and being convicted of child pornography, essentially. Here, however, a parent could put on this movie and show it to their child knowingly, and they wouldn't be convicted of distributing child pornography or offering it. Because, as stated, when you put it together, the statute as it reads itself, a parent may do so, or another individual may do so, but if they do so knowingly, for this purpose of persuading a child or inducing them to engage in this illegal behavior, this sexually explicit behavior, then they will.
In this case, it was sexually explicit. What happens if the if the behavior in question is, I want you to skip school?
Your Honor, this statute itself is not applying to these kinds of things. It's applying to
It can be.
Yeah, why wouldn't it be applicable to that?
Because there's this introduction of this mens rea element of knowingly doing so for this purpose of.
Counselor, you keep bringing up this knowingly, this mens rea element, but I guess I'm just kind of failing to grasp how that helps the broadness of the statute, because you can knowingly send a Renaissance painting that appears to depict a minor, which meets the mens rea element, but then you're still talking about a constitutionally protected piece of art, and if you're using it to induce truancy, that's still the kind of constitutionally protected activity that we're talking about.
Okay, thank you, Your Honor, for that clarification. See, there is under RAB versus City of St. Paul, that it's true that the First Amendment generally prohibits the government from prescribing speech or expressive conduct, but there is such a thing as content-based regulation. And though it is presumptively invalid, there are these exceptions, and we know that there is constitutionally prescribable content, that which is obscene, defamatory, or fighting words. Here, the issue is obscenity, right? And that which is obscene is not constitutionally protected, as stated in Ginsburg versus New York. And particularly as to the opposing counsel's statement that truancy, things of this nature. Here, we're not debating an individual's ability to simply speak to someone else or to seemingly whoever they so choose to speak to, but when they do so for this purpose, and it must be differentiated that there is this element of knowingly doing so.
Okay, no, there's a difference between the word knowingly and this purpose. Can you define this purpose?
Yes, Your Honor. The purpose of engaging in explicit behavior, which is illegal. Through this.
But that isn't in the statute. I think that's the biggest problem that we have with it.
Yeah. Okay. Yes, Your Honor. And as it was stated in Ashcroft v. ACLU and Ashcroft v. Free Speech Coalition, the reason why the CPPA was deemed to be unconstitutional because it was overbroad, as we are debating here today. However, the legislature here, the state of Lone Star itself, has recognized and adhered to this similarly worded enactment, which was deemed unconstitutional, and introduced this element in accordance with other previous court's decisions, and introduced a regulation that is specifically targeted to a particular element, an individual that is knowingly doing these actions with a minor for the purpose of engaging in illegal behavior through sexually explicit visual depictions. And as what I was stating earlier, a parent who might have been liable under the CPPA will not be held liable under the Lone Star Penal Code section 78.021. An individual, a minor, as my opposing counsel was stating, a minor cannot be held liable for showing another minor these kinds of things. For one, because it's not illegal for a minor to engage with another minor, it's illegal for an individual that is older. And Your Honors, I see that I'm almost running out of time, so may I state my second point?
Well, how long is your second point going to go, counsel? If it's more than a minute, the answer would probably be no. So just keep going, and then when it's time, you can conclude.
Thank you, Your Honor. So you see, secondly, as my second point, the statute itself does refrain from undue burdens on constitutionally protected speech through its language and adherence to these case law standards. And if you look again on page 6 of the factual record, the petitioner in their appeal of the 15th Court of Appeals stated that the First Amendment guaranteed them a right to engage in online conversations with whoever he so choose. Now, the state of Lone Star understands that the freedom of expression as protected by the First Amendment is of the utmost importance. However, the freedom and right of expression is not the right to knowingly engage minors through sexually explicit communications for the purposes of illegal activity. And as was previously stated in Ginsburg versus New York, the state has a compelling interest in protecting the general welfare of children and may do so with reasonable regulation. Thank you, Your Honors.
Thank you. All right, counsel.
Your Honors, may it please the court. My name is Justin Vineyard, and alongside my co-counsel, Jose Vega, together we represent the respondent state of Lone Star. I will be addressing the second issue before the court today, whether Esme Squalor's outburst unfairly prejudiced Olaf's right to a fair trial under the 6th and 14th Amendments. There are going to be two main reasons why this court should affirm the judgment of the 15th Court of Appeals today. First, being that Squalor's outburst did not result in an actual or inherent prejudice against the petitioner. And second, that ultimately, even in a best case scenario for the petitioner, the harmless error doctrine will require us to affirm this conviction. Moving on to my first point. The court in Marks provides guidance telling us that in order to constitute a reversible error based on the deprivation of a fair trial, the defendant must show that some courtroom procedure entailed actual or inherent prejudice. Starting off, we can see that there is no showing of actual prejudice here.
How do you know? I mean, the only way to truly know is to poll the jury afterwards to see if it made any sort of difference. Isn't that true?
I would respectfully disagree, Your Honor. In Ashley versus State, the court provides excellent guidance as to what constitutes a form of actual prejudice. In Ashley versus State, during the first trial for the defendant, the jury was unable to return a unanimous verdict. However, in the second trial, upon weighing the exact same evidence, only with the addition of a spectator's outburst, the jury was able to return a verdict. In that instance, there was a showing of actual prejudice because weighing the same evidence without the outburst, they were unable to return a verdict, but only with the addition of the outburst was the jury able to return a verdict. So we can see here that with the addition of the outburst, there was a showing of actual prejudice.
I'm sorry.
You're saying there was actual prejudice because of the outburst? Did I understand that correctly?
Excuse me, Your Honor. I was saying in Ashley versus State, there was an instance of actual prejudice there because there were two trials. Only in the second trial with the addition of the outburst was the jury able to return a verdict.
But can't we infer it? I mean, let's say that the judge had said, you're right, this guy is a child molester, but that's not what we're here to decide. I mean, can't we infer from that the jury has been influenced?
I would respectfully disagree with that characterization, Your Honor, in that the defendant must show that there was a form of actual prejudice. In situations like those, it would be important to analyze whether or not the procedure itself entailed a form of inherent prejudice, because it is more difficult to prove a showing of actual prejudice, which is why the court in Marks.
Here's the problem, counselor, is that according to your argument, the way that we should find out if there was actual prejudice is to have another trial. And if at the next trial, without an outburst, if there's no conviction, then we'll know that there was prejudice.
Your Honor, it is not the respondent's position that is the only way to show actual prejudice. As you brought up in your earlier question, you could poll the jury. The jurors could admit that it ultimately did impact their decision. Additionally, the threshold for showing actual prejudice is notably higher. It is more difficult to discern whether or not the jury was actually prejudiced, which is why Marks includes the second prong of inherent prejudice, which ultimately has a much larger reach in determining whether or not the procedure is going to be prejudicial inherently. Looking at page 6 of the record, on the most basic level to a showing of actual prejudice, only a few jurors admit that they heard the rumors of these allegations following a local news story, but ultimately there was no indication as to whether the outburst nor the news story affected their decision. Seeing as though there is no showing by the defendant of an actual prejudice occurring at trial, we can move on to the second prong of the test.
How would you suggest that defendants do that?
In this case, I would argue that there isn't particularly a way that they do that because there wasn't an instance of actual prejudice.
Well, no. It's like, but it's kind of like this is a revolving argument now because you're saying there's no prejudice and we can tell because there's no prejudice. What I'm asking is, for in the future, let's say this happens again, if we don't poll the jury, if we don't, and if we don't ask, if we don't give a limiting instruction and there is a conviction as there was in this case, how will we ever know if there was prejudice? You're assuming there wasn't.
Your Honor, I believe, Your Honor, this ties back to the inherent prejudice argument in that it is always going to be more difficult to have a showing of actual prejudice. And that's why the court in Marks doesn't say actual prejudice or inherent prejudice, or pardon me, it doesn't say actual prejudice and inherent prejudice. It allows the defendant to only have to show one, so that in an instance where there might not be inherent prejudice, there might be a showing of actual prejudice. But generally, the bar for showing actual prejudice is much higher for the reasons that you provide, which is why the defendants must or should be able to show that there is a showing of inherent prejudice, that the practice entailed a form of that is inherently lacking in due process. So to briefly answer,
that's what is being argued today, that without a limiting instruction, that it is inherently prejudicial. that without that limiting instruction, that there's a problem.
Your Honor, Your Honor, the respondent's position is not that the failure to issue a limiting instruction is inherently prejudicial. To look at an instance of inherent prejudice, the court in Estelle versus Williams provided a great example of what inherent prejudice is. And that's in that case, the defendant took the stand while wearing prison garb. The court reasoned that wearing prison garb has an inherent connotation of someone already being convicted, because typically those that are in prison, the ones who are wearing prison garbs, have already received a conviction. Comparing that to your question, in that the judge not issuing a limiting instruction doesn't have an inherent connotation of guilt, like the donning prison garb in Estelle versus Williams. Like in a vacuum, the failure to issue an instruction doesn't have any inherent connotation at all. The court in Marks versus State elaborates on this concept by telling us that a procedure that is inherently prejudicial is one that has such a probability that prejudice will result that it is deemed inherently lacking in due process.
Counsel, just really quickly, I just wanted to tease out your argument. Are you arguing that the statement that the outburst wasn't prejudicial, that there wasn't harm, or both?
It is our position that the outburst was not prejudicial, but if this court was to find that it was prejudicial, the prejudice was ultimately harmless.
So let's go to issue 2 really quickly, because I'm really let's stick with issue 1. You would agree that this is a case where we're talking about an extraneous offense, that it isn't that she's saying this guy is horrible, he's creepy, he's mean. This is the allegation of an actual felony, of a, actually, to be honest, a more serious felony. So how is that not in some ways potentially prejudicial? Because I could completely understand that if there was a limiting instruction, there's no problem. At that point, jury understands it's supposed to disregard. But since that isn't the case here, how is that not problematic of being ascribed to of an actual crime?
Your Honor, the court in Ashley provided additional guidance on this question in determining that the outburst itself, despite the weight of the crime, was not prejudicial. The outburst was only prejudicial because it introduced evidence that the judge had already twice determined to be prejudicial. So it's not the content of the allegation, but whether or not that the judge had already struck them from the record and determined those allegations should be prejudicial. Particularly following that reasoning, that's why there is no showing of inherent prejudice here. There was no, the allegations that were brought up in Ms. Squaller's outburst were not already struck from the record. Particularly, the court, pardon me, I need to clear my throat.
And while you're taking a drink, in a way though, isn't what is discussed, isn't the outburst even worse than what is alleged at court though? Because Count Olaf completely, he never denied sending or offering to send material. He just said that he didn't have the intent to elicit illegal activity, that he actually never even sent anything. He admits certain parts of that statute, but what is being alleged here is vile. It's sexual assault of a child.
This is particularly what the court in Ashley was attempting to address, Your Honor, and that it's not the outburst itself that it's going to be prejudicial, regardless of the content contained. Referring back to a question during the petitioner's arguments, that there's a public policy consideration to not allowing these outbursts to lead to an automatic mistrial. If it were possible for a spectator to simply make the loftiest allegations possible against the defendant during court, that would result in an automatic mistrial. It shouldn't be.
But counsel, couldn't you always correct that with a limiting instruction?
It is our position, Your Honor, that a limiting instruction would not be inappropriate in this instance. But however, it ultimately wasn't necessary to, or wasn't, ultimately does not require a mistrial because it did not result in any actual or inherent.
No. I'm responding to your public policy argument. I mean, I understand you're saying as a public policy, it would be bad to let a spectator's comment derail the trial, but couldn't a court always just give a limiting instruction, which would prevent that risk?
Your Honor, that is true. But today we're reviewing whether, today we're reviewing if we need to reverse the error or reverse the decision that was made by the lower court. It would not have been an error for the court to have issued a limiting instruction, but if we want to reverse the decision that was made by the lower court, we have to still have a showing of actual or inherent prejudice. So it would not be incorrect. I do agree with your contention that.
So how would you suggest that defendants show actual or inherent prejudice?
Looking to, for one, the bar for actual prejudice is going to be much higher. There's not going to be a common procedure for the defendant to be able to complete this showing of actual prejudice for the reasons that you articulated. It's difficult to get into the mind of a jury. It is possible to pull them afterwards. It is possible to have a niche scenario like in Ashley, where there was 2 trials, which is why the threshold is going to be much higher for a form of inherent prejudice. And to that end, the court in Marks provides guidance as well that the practice that must have occurred.
Wait a minute, counsel. I think you just told me that there has to be a showing of actual prejudice, but it's impossible to prove actual prejudice, which does not sound very constitutional to me.
Your Honor, the court in Marks tells us that in order to reverse this error, we need to have a showing of actual or inherent prejudice, not both. The threshold for actual prejudice is going to be much higher, albeit not impossible. You could always poll the jury. You could have a scenario like in Ashley with 2 trials, but it's not impossible. Though even if it is extremely difficult, that is why there's the option of the showing of inherent prejudice as well.
Okay, so I'm sorry, let's clarify, because obviously this is one case, but we're talking about future cases. And so what I'm worried about is if we let this go, then in future trials, you'll have people having outburst of, oh, this person did this introducing all sorts of extraneous offenses, some of which have been ruled as inadmissible in motions in limine. So you're backdooring out inadmissible evidence. How do we fix it if there's no limiting instruction? You said that what should future juries do? Because there's not going to be 2 trials. If there's a conviction, we'll never know.
Your Honor, in this instance, the evidence had not already been declared to be prejudicial and was excluded from the record.
No. You're telling me what's happened in this case. I want you to stop and tell me, and it's okay, I know you're about to go over, how in future cases, what should we do if it's not a limiting instruction? What should happen in the future?
We should follow the guidance set out in Marks that there must be a showing of actual or inherent prejudice. This creates a test that allows us to not only allow spectators to go unchecked, nor the extreme other end, we're forcing a mistrial due to every spectator's outburst. Okay. May I briefly conclude, Your Honors?
Actually, I think we're fine. I understand the conclusion. You want us to affirm. So thank you very much.
Thank you.
And now we have a rebuttal.
Thank you, Your Honor. May it please the court. We'd like to address 2 points on rebuttal. First, related to the statute itself, we would submit that the government that with any content-based restriction on protected speech is presumed invalid, and the government has not met its burden here of showing that the statute is the least restrictive of effective available alternatives. And so the statute cannot survive strict scrutiny. So we dispute the state's contention that this is narrowly tailored and meets this standard. We believe it does not. And secondly, it seemed that the state concedes that a limiting instruction would have been appropriate in this case. And since there was not one, there was a constitutional violation of Count Olaf's 6th and 14th Amendment rights. We agree that a limiting instruction would have been appropriate. And since there was not one, we asked the court to reverse and remand for a new trial, or to strike down the statute as a violation on the First Amendment.
I think you're confusing whether it's appropriate or required. He says it's appropriate, but not required. And could you just briefly address that?
Yes.
Your Honor, we believe it should be required. And I think the questioning and the state's presentation sort of talked about that circular logic. There's no good way to show inherent prejudice, but I think you can look at on the face of what the jury heard and saw and just use your reason to see that that seems pretty inherently prejudicial and a violation of his Sixth Amendment rights. So we think a limiting instruction should have been required. Thank you, Your Honor.
Thank you.
Thank you, counselors.
Yes, thank you, counselors.
Thank you, counselors. Oral arguments are now completed.
All right, wonderful. So what will happen at this time is I will open a breakout room for all of our judges to enter, and the decision will be made as to which team came out victorious today, as well as best speaker of today. So those are your two objectives. So I will add all of our judges right now.
Are you going to move us over? Or do we need to do it? Okay, here we go. Got it.
So we are still live on YouTube as we wait for the judge's decision. All of our competitors are encouraged to turn your camera off, relax if you'd like, as we wait.
There we go.
Sorry,
Yeah,
The judges reached a decision.
out. Yes, we have reached a decision. We would like to congratulate everybody, but we also would like, let me see if everybody's here. Yes, everybody's here. We would like to congratulate everybody for getting this far. We have deliberated, and the winner of this year's 2022 John Black Moot Court competition is Team 1, the petitioner. We would also like to congratulate our best speaker, Nathan Helene.
It's correct. I think we all concurred.
Yeah, good job all around. You know, it was a tough fought round, and you know, it was great to hear everybody's arguments, and you know, you guys both deserve to be here. So thanks for putting on a great show for us.
Absolutely. Now I believe that we've been asked to give a little feedback. So if my co-justices would like to give a little feedback and introduce themselves to the panel, so at least y'all know who you're talking to.
Sure, Alex, you want to start?
Sure, yeah, I'd be happy to start. My name is Alex Johnson. I graduated from the Law Center in 2020. I did moot court my 2L and 3L year and won John Black my first year. And then since then, I have been working with a civil rights attorney, and I focus on the appellate side. I mean, I kind of do a little bit of everything right now. Thankfully, we've got a lot of appeals, so it's been good. So yeah, this is all stuff that, you know, I've actually seen before in my practice, dealing with First Amendment issues, dealing with, you know, high level, broadly similar fact patterns. So yeah, this was definitely a fun problem, and yeah. Should I, Douglas, would you like to introduce yourself, or do we want to go straight into feedback?
Why don't you go ahead and jump into feedback, and we can each, yeah.
All right, yeah, since there's three of us, I'll try to keep it pretty quick. Yeah, so two global just style things, and this might just be me, so if the other judges disagree, feel free to do so. The two style things being, you don't have to use the number of the statute every time. We're only talking about one statute. You can just say the statute. You know, it's a lot of syllables, and it can kind of depersonalize it a little bit in my mind. And then the other thing that I think almost everybody did was asking to conclude when, you know, you still had time on the table. And it's just like, if you're already finishing answering the question, you can just go straight to your conclusion. If you need more time to answer the question, that's when you ask for more time. So that's just a little distinction there. And I know I had given feedback in a previous round about that. But I mean, just the clarification there being, you can always conclude as long as you have time on the board. Mm-hmm. But yeah, so going first to Mr. Helene. Yeah, your roadmap was good. A touch long, could have been a touch cleaned up, but I mean, other than that, very good. I kind of knew who you and your partner were. I knew what you were going to be talking about. I knew kind of the progression you were going to make through your argument. So that was all very good. One thing that I would like to see when you hopefully join the moot court team would be transitioning out of answering questions. So a couple of times you use the "does that answer your question?" And that's good when the question is confusing. There are sometimes where you genuinely don't know, and you kind of get the sense that, the back and forth with your judge might not be finished. But a lot of times you'd give it a complete answer and you were good. You could have just gone straight back into your outline, but just that extra pause just kind of makes it feel a little bit more clunky. But yeah, and then if you ask for time to conclude, keep it short, keep it simple. So just, we're asking you to vacate, and my partner will explain why you should reverse, even if you disagree with me. I mean, obviously that was a very casual way to say it, so less casual than that. But yeah, yeah, that's all good there. And then Ms. Gillespie, yeah, you did a good job bringing in record sites. You went out of your way to do that, and you weren't asked for record sites, so that was good. I like to see that. That's a good way to score points. I liked, at least at first, you did a good job of answering within the framework of the question. But then in later questions, I noticed you started using a little bit more passive language. It may be that, it's likely that, but you're advocating for your position. You believe in the position that you're arguing. It's not the case that it may be prejudicial. It is prejudicial. You're arguing that this is the case. We are right. So just having that confidence and making sure that you're showing that confidence with the language that you're using. But yeah, and then there was one other thing. Oh yeah, and then there was one question where you mentioned cases, and then when you transitioned back into your outline, you then talked about the cases. You could have just talked about the cases and transitioned back into the outline a lot more smoothly there. So yeah, just that getting out of questions thing. But I mean, that comes with practice. So I mean, that's kind of to be expected. So definitely something easy to clean up. Mr. Vega, yeah, I appreciate that you had an outline, that it was kind of clear where you were going, but there's a lot of ways that there's a lot of places to kind of clean it up. Just in terms of it just felt a little bit long, and then that cuts into your time to be able to argue. So to the extent that could be cleaned up, having your theme up front is definitely, it's good. It's definitely a way to go. There are some judges that like it more than others. So just so you know that that's just kind of a style consideration to make. And then, yeah, I just felt like you did good, you did good, like responding to us, like we could, there was definitely that, like a back and forth, and you were respectful about the way that you disagreed with us, but the way that you were answering the questions, it just kind of felt like it came back to the same things, without necessarily answering the new questions we were asking, if that makes sense. So just, make sure that you're paying attention to the kind of thrust of the question, and you're direct about what you're responding to. But yeah, and then just with the conclusion, you noticed that like the time was up, or the time was close, and you started to ask for more. So it showed that you were aware of it, but then it kind of took all that time to kind of get through the second point. So, if you're aware of the time, then, that's fine. It's kind of fine to quicken it up, but just make sure that you're getting everything in the allotted time. And then Mr. Vineyard, yeah, it was, your intro was quick. It was pretty good. I personally am of the opinion that you don't need to reintroduce your partner. That might just be me. And then just in terms of body position, it looked like you were looking down at first. I kind of got used to it. And that's definitely a weird thing with Zoom. I've argued in person and in Zoom. So I kind of know that it's weird with Zoom getting the setup just right and making sure the height's right. But it's something where if it looks like you're kind of more like this, it looks like you're reading off of something. And I don't know if you were, because obviously I couldn't see what was in front of you. But just the way that the posture was. So that's just something to be aware of to the extent that competitions are made over Zoom. And then, yeah, the same thing about answering questions. Just make sure you're directing your answers at the thrust of the questions that are being asked, and not necessarily like recycling into the outline, because that's just how it felt at some points. But yeah, other than that, yeah, like I said, good job all around. So I've gabbed enough, so I'll pass it off.
So I guess I'll jump in here. So my name is Doug Darsh. As you might be able to tell from my background, I work for Baker Hostetler. So I graduated from the Law Center in 1995. So I'm a grizzled old civil litigator at this point. So I'm kind of bringing in a little different perspective. I don't do much appellate law. I've argued, I want to say 3 appeals through the course of my career. So that's not a big part of what I do. So Nathan, start with you. I mean, I just got to say that was one of the best oral arguments I've ever seen. I've been judging these competitions for 20 plus years. I mean, you had great eye contact. You had a great grasp of the subject matter, which in some areas is really complicated. You did a nice job of addressing the questions. I think you were asking, and I think the comment was made, you said a couple times, does that answer your question? I didn't think you really needed to do that. Answer the question, maybe a little pause, and then just move on. I thought it was clean and just excellent. I really thought you did a good job with the argument. Beth, you also had a good grasp of the subject matter. There were a couple times where, especially when answering a question, you would say something along the lines of, I think, or we think, like, we think that X, Y, Z. I don't care what you think. None of us judges care what you think. What we care about is what the courts tell us and what the statutes tell us. So don't tell us what you think, but say, the court in Ashley answered that question by saying X, Y, Z. So that's just kind of a stylistic thing. Jose, I thought you had one of the most difficult back and forths with my fellow judge, who was asking a super convoluted, if part A and part B, and I get that. I mean, I was even struggling to follow it, so I get that you had a hard time following it. And then you asked her to restate it, and she restated it, and it ate up a lot of time. And I get that was tough. It might have been better if you could have restated it yourself, as at least what you understood she was asking, and maybe even frame it a little bit so that it supports your argument, and then gone down that way. And I'm confident she would have interrupted you and told you if you were framing it incorrectly, but that would have been my kind of only guidance on that. And then Justin, yeah, I agree with what Alex said on the presentation that you had. So I don't know what your setup is there, but it looked like you were reading the introduction verbatim from your notes, and then your eye contact was just strange. You were looking down a lot, like I'm looking down now, and your eyes would kind of dart around, and it may be just your setup there, but you want to have a presentation where you're looking into the screen. And the way that my Zoom is set up right now is that I'm looking into the screen, and all of us lawyers who didn't know what Zoom was 2 years ago, now we're very conversant with it. So, however you need to change your setting, you need to be making eye contact with us, because it's a lot more effective. So that's all I've got. Thanks. Great job by everyone, though.
I'm Cassandra Jew. I practice criminal appellate law. I'm a legal clinic supervisor at the University of Houston Law Center, where I direct the Texas Innocence Network and under Professor David R. Dow. And I also coach a moot court team, the ABA NAAC, and I've been doing that for UH for a lot of years, over 15 now. I did a count recently. So everybody did a great job, and my fellow justices have said a lot of what I would say. There are a couple of things that I'm just going to talk about globally for you in terms of your future practice. There aren't as many appellate arguments that are being granted these days, but in a lot of ways, I feel that appellate work is very similar to hearings practices, and you will have that, in that your audience is a court, and the people that you will be talking with and against are people who are also conversant with the law versus, let's say, a jury. You're going in front of a jury and you need to explain the law. So everybody has been briefed. And for that reason, I always feel that it is a mistake to ask for a recitation of the facts, because everybody comes to you and everybody knows what's happening. And if I'm going to be super ultra picky in a moot court competition, it only goes badly for you if you do a recitation of the facts, because either you stumble or else you tell us stuff that we already knew and expected to hear. So just be careful. When it comes to the law, each of you showed me that you absolutely understood the cases that had been assigned. You knew the holdings, you knew the facts, you knew them better than we did. But what you need to do whenever you have this type of problem is to think beyond the problem. Think beyond your Count Olaf. Think beyond this conviction, because there's the next conviction and the one after that. And that's what we're really worried about. There were times, for example, where I think it was you, Beth, who said, look, you may not, in this case, a limiting instruction was absolutely necessary. In other ones, I can give it. I don't care about them. I would have liked it if you cared about them a little, but just at least you went for your clients. So always understand what you're asking for, the implications of what it is you're arguing. With that in mind, you should also anticipate, hey, if I argue for this, what will be the implications? If you're saying a limiting instruction is never necessary, then what happens when there are future people who jump up and say, that guy, he sexually assaulted me. I know he's here for a traffic ticket, but he's a rapist. That could be bad. So think that through. Also, there are going to be times where a judge may not like they don't like your argument. They don't like what it is you had to say. You need to quickly think, all right, so that's one way to address it. Let me get to plan B. So, okay, so this is what I would love, but if what I love doesn't work, then at the very least, I would like this. You'll also have to think about it and go, all right, are there things I can concede? Are there things that I can say, I can give up this small, tiny battle if I win the war? So just think these things through in terms of your practice. All of you, just stick with your conversational styles. Don't try to be anybody else. And all of you are on the path to that. So on the whole, everybody did a very good job, and I'm very pleased to see everybody going at it for your first year in moot court. I wish you all the best for your next couple of years in law school, and thank you very much for being here. With that, I hand it back to Michael.
Thank you so much. Professor Ju, did you have individual feedback for our competitors?
I believe that my co-justices said what I would have gone through. I don't want to be repetitive.
Great. Absolutely. Well, congratulations to Team 1, and congratulations to Nathan for also taking home the Best Speaker Award. So I'm going to close out the YouTube live stream, and then we'll take some photos afterwards. So let me do that. Give me 1 second. To everyone watching on YouTube, thank you for tuning in. The Advocates host competitions throughout the year. So be sure to subscribe to the YouTube channel, and Blakely UHLC as well on YouTube.